Okay, I'm going to admit to you, I like to talk a lot, but that's only about what I know. And when it comes to the law, the history of law, the history of the rule of law, you know, basic obligations of public service, yeah, I like to talk about things that I know about. When it's things I don't know about, I tend to remain silent. But this I do know. Okay, individuals who constitutional and other federal rights have been violated by federal and state government officers may bring Section 1983 lawsuit or Bivens claim against those officers to recover damages. Okay, so there's a lot of questions they're asking here. Okay, but I want to get here. Okay, Section 1983 lawsuits. Individuals whose constitutional and other federal rights have been violated by federal and state government officers may bring a Section 1983 lawsuits or Bivens claim against officers to recover damages. A Section 1983 lawsuit is the right way to use an official who works for a state or local government, and a Bivens claim in the way someone can pause a federal official when that official has violated the person's constitutional rights. Both sections, 1983 and Bivens claims, allow you to recover from the government for any damages resulting from the violation of your rights, including physical, mental, and emotional injuries. You can also seek punitive damage and attorney's fees in certain cases. And while they have similar functions, namely deterring unconstitutional actions such as a conspiracy to deprive rights under the color of law, there are important differences between Section 1983 claims and Bivens claims. What is a Section 1983 lawsuit? Section 1983, which is a short for 42 Section 1983, gives people the right to sue state government officials and employees who violate their constitutional rights. All right. Originally passed during Reconstruction. Okay, so this is old, right? Okay, you hear the U.S. Supreme Court saying we're going to go with these old laws. Well, let's go with these that they ain't telling you about, okay? If you read the Rules of Professional Conduct and the preamble, it's the legal system that's supposed to be making sure you know this. Okay, every person who under color of any statute, ordinance, regulation, custom, or usage of any state or territory of District of Columbia subjects or cause to be subjected any citizen of the United States or any other person within the jurisdiction thereof to the deprivation of rights, privileges, and immunity secured by the Constitution and laws shall be liable for the party injured in an action at suit in equity and other proper proceedings for redress. Because states are immune from lawsuits, Section 1983 claims have been brought against specific government officials or employees who violated your civil rights. Okay, which I explained to you before. The conspiracy to deprive rights under the color of law. You're all a victim of it, okay? All you got to do is go over the Rules of Professional Conduct, Code of Judicial Conduct, and you'll figure it out for yourself. But I'll help you along the way. I got a lot of posts on legal reform that explains it all to you. Not in one post, but, I don't know, there's a couple hundred. Oh, okay, for violating your rights, sometimes it means suing the state's elected officials to block an unconstitutional law from taking effect. While state agencies and local governments can also be sued for violating your rights, the rules for suing them are slightly different. Rather than being able to sue the local government when one of its employees violates your right, you can only sue the local government if it was a local government policy that led to your rights being violated. Okay, so if it's policy that's violating your constitutional rights, and remember, any law repugnant to the U.S. Constitution is null and void. But they will write laws that are null and void because you don't know that those laws are repugnant to the U.S. Constitution that make them null and void. Okay, but all you have to do is put in your search engine, I explained it in some other videos. I'm sorry, my mind's going in a dozen different directions right now. Policy to let to your rights being violated. Local government policy include both official rules, decision by authoritative policy makers, and informal common practices that are de facto policy within the local government entity. I mean, a lot of people are upset with what's going on out there. Local government, state, federal, Bivens claims, named after the Supreme Court case Bivens versus 6 unknown agents, are like Section 18 claims that they are brought against federal government officers and employees that are far fewer Bivens claims than Section 1938 claims. Unlike Section 1983 claims, sorry, I mispronounced that. When local government agencies may be sued, a Bivens action may be brought against any federal government agency. It is only used as a basis for lawsuits against individual officers or officials, not the agency in its entirety, just the officers. Remember my post where I was saying that everybody, working, enforcing laws and making laws should have mandatory legal malpractice insurance, so that way, their legal fees don't come out of the public coffers, taxpayer dollars. Another major difference between a Bivens claim and Section 1983 lawsuit is that a Bivens claim is limited to constitutional violations and typically may not use violations of federal statutes as a basis of recovery. And it's easy, like I said, when it comes to the courts. Basically what they're talking about here is, policies, like police policies within the FBI, so on and so forth. So there's a difference. When Congress has provided separate means of vindicating violations for constitutional constitutional rights, a Bivens action may be permitted. For example, because the Civil Service Commission provides federal employees with the comprehensive remedial scheme, a federal employee cannot use his supervisor for damages. A Bivens action claiming First Amendment violations, and most people who are injured by an employee of a federal government must pursue any claim for damage under the Federal Tort Claims Act, or FTCA. When do government officials violate someone's constitutional rights? There are a variety of different ways a government official may violate someone's constitutional rights, but most Section 1980 lawsuits of Bivens claims are brought when an official of the state or federal government violates someone's 4th, 5th, or 8th Amendment rights, or the following. Shooting by law enforcement against unarmed citizens, or other cases of police brutality or excessive force, false arrest by law enforcement officers, and malicious prosecution. That's what I've been telling you. Malicious prosecution is everywhere. When there is no probable cause or evidence of criminal wrongdoing, but the state's prosecutor's office will still do that. The police will still file a false police report. They'll have no probable cause of arrest and still arrest you. Okay, and remember I told you that judge threw it out for no probable cause. So that's a false arrest. No probable cause evidence of criminal wrongdoing. State and federal law enforcement officers searching through your house and seizing your property without a valid warrant. See, I don't know if anybody's telling you this. I seriously doubt it. Without the internet, I don't think anybody would believe me. Nobody actually does believe me most of the time. If you are a prisoner and you are beaten and injured by the guards, or if the guards deliberately ignore your medical needs, a lot of people in prison are complaining about that, but they don't know where to sue and how to sue and what to sue for. Okay, anybody in prison, you do still have constitutional rights. Look it up. Just Google constitutional rights for the incarcerated, and you will find them. Okay. And as far as this goes, if you are a prisoner and you are beaten and injured, remember that falls under violating the Ninth Amendment, I think it is. Google cruel and unusual punishment. Okay, so it's a violation there. And they are legally required to keep you safe. Look it up. It's on the net. Okay, school or government employees who punish or censor a student or public employee for exercising their right to free speech or religion. And it's happening now all over the United States. Schools or government employees who punish or censor a student or public employee for exercising their right to free speech or religion. Okay, so I'm just letting you know what you can do, okay? Listen, I've been pushing a lot of this stuff and trying real hard with lawyers and judges, the courts, talking to politicians, and I'm going to show you the few that answer me. I showed you the one from the FBI. So I have no qualms with the FBI. They do what they do, and I know what they're supposed to do, and they do it. Most of them are pretty damn good at their job. DOJ. I keep an eye on what they do, and I enjoy their work on cybersecurity attacks. They putting them out on the street. What the hell is wrong with it, people? What is qualified immunity in Section 1983 lawsuit? When a police officer or other government official is facing Section 1983 lawsuit or Bivens, they will almost always try to get out of it, raising the defense of qualified immunity. Remember, I told you in one of my videos, the history of the rule of law is in the Magna Carta. It's called the Magna Carta, or the Barons' Wars, or the Great Charter, and it specifically states the rule of law was established to abolish qualified immunity. So qualified immunity is contradictory and to the rule of law and not conducive with the public interest. Okay, so you can always bring that up. Qualified immunity automatically puts anybody that claims it above the law. Okay. Qualified immunity is a legal defense to Section 1831 lawsuit. It allows a police officer or other official to escape liability if the constitutional right the officer is accused of violating was not clearly established under federal law at the time the right was allegedly violated. Okay, I mean, they do it on a constant basis. If you ever read the Constitution, or the policeman's oath, they always violate the policeman's oath. Just that alone. Violating the oath is breaking the law. Okay, look up the penalties for violating the oath. Qualified immunity. That was created under the color of law. That is part of a conspiracy to deprive rights under the color of law. As you might expect from such a vague phrase, whether a law or right is clearly established can often depend on whether the judge thinks, while all judges consider Supreme Court precedents and cases in their own circuit, many disagree on how similar the facts of a prior case have to be in the facts in a current case and prior case can be considered clearly establishing law. Others also disagree on whether or not lower opinions, guidance, or federal guidance agencies and other sources can clearly establish the law. Not only is it difficult to establish that a right was clearly established at the time it was violated, but government defendants who are denied immunity are allowed to appeal that decision before a trial. That gives the government a considerable amount of time during which plaintiffs can run out of resources and be forced to drop their case. And that's why I always keep telling people there's no way you're ever going to get a fair trial without effective assistance of counsel. And you're not going to be able to afford effective assistance of counsel because effective assistance of counsel doesn't exist. If they're violating the rule of professional conduct and the code of judicial conduct, which all lawyers and judges do, they're violating your right to effective assistance of counsel. Okay, so you're literally got everybody in that courtroom working against you, and right here what they're telling you works against you, but not if you bring up the conspiracy to deprive rights under the color of law. And then state everything in the rules of professional conduct and the code of judicial conduct that wasn't done, which are the requirements of all lawyers and judges in a court of law. Okay? So they count on you running out of resources, as they say, money, going broke by the time it hits the Supreme Court. And that's the whole play. They keep appealing, and there's no way you can afford a lawyer. The only way you could afford to compete with them in a court of law is if you have a law degree, the legal knowledge necessary to compete with the learned, educated professionals in that court of law. But you don't have that. How is that? How did you have a fair trial to begin with? Yet alone, how is it fair that they can continue this? It's a travesty of justice. In every stance, you're living under the color of the law. Our constitutional rights attorneys can help you win a Section 1983 lawsuit. Our firm is one of very few with a record of success in Section 1983 lawsuits, Bivens claims, and other constitutional rights litigation. We know how to pursue police officers and other government officials who violate people's constitutional rights from our decades of work in the serious criminal defense cases. We are not afraid of taking on corrupt or incompetent law enforcement officers when those officers violate our clients' civil rights. If you or a loved one have been victim of excessive force by police or wrongful search of your home, property, or have any other type of constitutional rights, okay, I guess it is from a law firm. Yes, a church law firm. But they're telling you the same thing I would have. Okay, somebody asked me if I knew of a law firm that would help on this. He's having problems in child custody court. Quite a few other people are too. And they're quite good at what they do. It's just that they're not lawyers. And they're doing all the paperwork. They're doing everything right. The judge is literally holding them to the legal knowledge of a seasoned professional. But yet, not the seasoned professionals. And they're even citing the violations of the rules and codes. They even brought out that it's a conspiracy to deprive rights under the color of law. I don't know, but either way, I mean, I know about that, but I'm not sure. I mean, I've never been able to trust a lawyer that wouldn't speak to me about the rules of professional conduct, the code of judicial conduct. And for the most part, when it comes to the law, any law, when I spoke to them, they like to give their version over what is written. I know what is written isn't etched in stone, but still the letter of the law requires it to be done word for word to the letter. Okay, and it's rarely that I get that from attorneys. Okay. Let's go back to where I was at. Victim of human right violations denied, know your rights. The 14th Amendment due process clause, okay. Okay, I'll go over that next, okay? Thanks for listening.